Well, good afternoon, good evening, good morning, whatever time you're watching this. We're good to have you along. John Scholes here, Sivan Tumarkin as well, disability lawyer, and welcome to the Disability Law Show. Got a lot to cover again this week. Feel free to reach out anytime after the show to Sivan and his team. They're always ready for a chat to help you out. The toll-free number, and by the way, there's no charge for a consultation, so there's no reason not to reach out for sure. 1-855-821-5900 by phone, help@disabilityrights.ca by email. We'll give you that throughout the show as well, if you didn't catch it that one time. Always have a main topic as well, by the way. This week it will be chronic stress and qualifying for disability benefits. Emails, phone calls, and all kinds of good things over the half hour. I can guarantee you this much, you're going to learn a lot every week on this show, so stick around for all of it. But success story, case of the day, week that was, whatever brand you want to give it, pal. What do you got going on this week?
So I had a case prepared, John, but then on the way here to do the show,
got resolved.
I got an email that I wanted to read out.
All right.
It's an individual who's watches the show, and just so happened that he emailed me as I was coming here. And I'm not going to mention his name or the particulars, but I'm going to read a particular paragraph that he wrote because I think it's very relevant to many individuals out there. He says, "Good day, I'm requesting your help regarding an LTD claim from my insurance company that was closed last year in July. He's dealing with mental health issues, PTSD, also some substance abuse issues with alcohol, etc. This is the key here. He says, I feel the case manager," he's talking about his adjuster, his long-term disability adjuster. "I feel the case manager exercised her own personal diagnosis and made an uninformed decision without understanding my situation and then he explains what he does, which again, I don't want to mention. So I want to focus here on this thing because it does happen quite often when people come to me and say, look, my case manager, my adjuster, whoever's dealing with my LTD claim seems to be substituting their opinion for the opinion of my doctors. They say, well, you know, we don't agree with your doctor, or they say that, well, I think that, you know, perhaps you're not trying hard enough, whatever the rationale is. Some of these adjusters think that they have the ability or the right. I can tell you as a fact, they don't have the ability or right to do so under the insurance policy. Remember that when you are on long-term disability or applying for long-term disability, you are essentially applying for benefits under a contract of insurance. That contract of insurance is that policy. You can request that from your insurance company or your employer, whoever it is that's managing the policy, so you can have a copy of it. But that policy, which is many pages long, defines the relationship between you and the insurance company. It sets out the insurance company's obligations, okay, and their rights, and your obligations and your rights. Nowhere in the policy does it say that the adjuster adjudicating your claim has the ability to substitute their opinion for your doctor's. Regardless, I see this quite often. Now, it's both good news and bad news for this individual and just generally speaking. Why? It's bad news in that by doing this, the adjuster is doing something incorrect, which is skewed towards the insurance company because this adjuster is obviously substituting their opinion in favor of the insurance company against your doctor. But it's good because it makes it that much easier for us to go after them and force them to pay you what you're owed if they deny your claim or if they give you a hard time. Now, most people out there will not know this. Most people out there will understand that there's something inherently wrong with an adjuster saying that I think your doctor is wrong without providing any medical contrary indication or evidence. But most people will not know what to do about that. Most people will be paralyzed in a way. So I am telling you that we can help you with those kinds of cases. Anytime your adjuster steps out of bounds, anytime your adjuster does something they're not allowed to do, or you have a spidey sense that's telling you something is wrong here, something is off, reach out to us. We will tell you. We do this day in and day out. We've seen countless policies. We've reviewed them. We have internal discussions within my team for all the major insurance companies across Canada. I am telling you, we can help you. We can tell you if what the adjuster is doing or saying to you is correct or not correct. And it's, you know, the best part is it's going to cost you nothing, literally nothing. We advise people each and every day about their rights. And you know, what's more important, I think, is we put people's minds at ease because we explain to them the legal framework. They explain to them, here's the landscape. Here's what your options are. Once you know what your options are, generally your anxiety goes down because now it's not like you don't know what's going to happen. We tell you, here's what's going to happen, here's what you can do about it, here's how we can help you. So again, this was a very timely email, but I get these all the time, different kinds of emails that sometimes we read on this show, sometimes we don't. But people need to understand, John, they have a lot more power than they think they do. And if you think something is wrong with your claim, if you think the adjuster, the insurance company, is doing something they're not supposed to, even if you can't put your finger on it, but something senses wrong, reach out to us. Let's have a discussion. Let us talk to you. Let us explain to you what your options are. Let us guide you in the right direction.
You know, you've mentioned several times in the show over the last few years, Sivan, that you used to work for insurance companies. So you can look behind the curtain and see what goes on. So, I mean, I can just say this as I've never been an insurance adjuster, but that's something I would never say to a client. I don't think your medical, I would not play doctor. Are they told to do this, or is this just a massive overreach by the adjuster and they're going to get a wrist slap by the company, by the insurance company? Or do they all do this in an attempt that they'll shake you off claim?
So they don't all do this, number one. Number two, I don't have any evidence to suggest that they're told to do this. Here's what you need to understand, though. These adjusters don't work for you. They work for the insurance company. How do insurance companies make money? They collect premiums, and then they try to not pay claims or pay as little as possible. So these adjusters have a mandate of managing these claims. How does it work from one insurance company to the other? I don't know. But clearly, as you can imagine, the adjuster has to report to a manager who then reports to somebody higher up, all the way up to the VP of claims, all the way up to the president. So the reality is that there is an incentive there for the adjuster to try and figure out how to stop paying you or pay you as little as possible. It's just the way that it works.
Sounds like a bit of a Hail Mary in this one.
It is a Hail Mary, but it works. It works because many people just accept it. Many people say, oh, okay, well, I guess I don't qualify. I guess I'm not disabled enough. I guess my doctor is just not good enough, or maybe I just don't qualify. So they take it at face value. That's one of the biggest problems with insurance companies, with people dealing with insurance, is you take what the insurance company says at face value, assuming the insurance company must know what they're talking about. It's in their wheelhouse. They must know what their policy. The adjuster, that's what they do for a living.
Right.
Yeah, but they have an agenda. And their agenda is to make money for the insurance company. And one of the ways to do it is to see if they can get you off claim. If I was wrong about this, my profession would not exist. Lawyers like me, well, I'm not the only one, there's other firms, other lawyers, we wouldn't exist. Why would the insurance companies pay on these cases? But let's assume for a second that we represent 100 people a month and get them settlements. Just throwing a number, it could be 1,000, could be whatever. How many people out there, John, do you think decided not to call us, decided to accept what the insurance company says at face value? How many people walked away from money that's owed to them? Mm-hmm. So these insurance companies are racking up billions of dollars because many people either are ignorant or are too afraid to ask questions and to stand up for their rights. So we're telling you, we are here to educate you, to explain to you your legal rights. And yeah, I used to work for insurance companies. I used to have clients who were adjusters who, I can tell you, didn't really know what they were doing. But there are some adjusters who are fantastic, who really know what they're doing. So, I mean, it depends on the person. But it doesn't matter. The point is you have to watch out for your interest. And if you think something is off, ask questions, get help. Again, doesn't cost anything to speak with me or any member of my team.
PocketDisabilityLawyer.ca. Tell me about it.
That's a website we created several years back now. Very, very good website, anonymous, quick, informative. Essentially, if you have any question about your short-term or long-term disability claim, you can go to this website. There's some pull-down menus, find what the issue is that you're searching, whether it's a denial of a claim or surveillance or appeals, whatever it is, and just see what the answer is to your particular question. If you want more information, contact us. But, you know, I tell people, be careful of Googling your questions when it comes to long-term disability. It's just, AI is not there yet. It's just not. It can give you incorrect information, outdated information. LTD law changes depending on the jurisdiction. If you get an American website, it's very different than Canadian. It's different. Different law firms provide different information. I don't agree with all the information on some of the other law firms that I know that they have on their websites. So if you go to PocketDisabilityLawyer.ca, I can tell you the information was vetted by me, by the partners at our firm. It's correct, and it's a good starting point.
Phone calls. You know, we get a lot of them on the radio show, which, by the way, 30-minute or 60-minute, depend what market you're in. Sivan Wholesome and other lawyers and his firm Wholesome as well. DisabilityRights.ca to find a radio station near you to catch the show and tune in and call in as well. Our first phone call from there right here is coming up now. Listen.
An investigator, I believe, sent by the insurance company recently showed up to my house to interview me. They asked a lot of questions about me being able to do another type of job. I didn't know this would be happening. Nobody communicated with me that someone would be coming to my house. Can they do this? I haven't even been cleared to return to work.
How stressful is that? You get a...
Yeah. So that's very odd.
Yeah.
So she mentioned an investigator, and my mind jumps to a private investigator. Well, I can tell you if it's a private investigator, they're not allowed to interact with her. There are very clear guidelines and restrictions on what private investigators can do. Insurance companies can hire them. They can take photographs, videos, not in your home. They certainly cannot talk to you, certainly not without your permission. So this is very odd. But this person apparently spoke with her about occupation. It almost seems to me like she was, she was set up to speak with some kind of an assessor. Somebody that the insurance company utilizes to figure out whether or not you have other qualifications, whether you can do another occupation. Typically, we see this when the person has been on LTD for about a year and a half. They're approaching the 2-year mark where there's a change of definition, where you have to show that to continue getting benefits, you can't work not only in your own occupation, but any occupation for which you're suited for. So this seems to me like this was an assessor of some sort. But these kinds of things need to be organized by the insurance companies in coordination with the individual. They're supposed to give you a heads up about that. So this whole thing seems very, very strange. Yeah. My suggestion, if something like this happens and you don't know anything about it, you say, I'm not talking to you. Yeah. I'm not speaking with you. My adjuster needs to inform me who you are, what this is about. Remember, you have rights. This is not the FBI, okay? This is not some law enforcement agency from wherever coming to you and saying, we have the right to speak with you. It doesn't work like that. Insurance companies, again, are governed by laws. Their behavior is governed by laws. They cannot do whatever they want. If they want you to be seen or for you to interact with someone that will assess you in any way, whether it's a doctor, occupational therapist, whatever, they need to give you advance notice. Not today to tomorrow. We're talking about weeks, if not months. They need to tell you where it's going to be. They need to tell you, here's who this person is. So there's a bunch of things. So this is all very strange to me, and I would tell this lady, give me a call after the show. I'd like to speak with you because something is off here. And if the insurance company crossed some kind of a boundary here, we can go after them for this. This is not allowed. Again, John, insurance companies are not infallible. They make mistakes because they're run by individuals, by adjusters. Sure. So understand that if the insurance company made a mistake here, you should not be paying for it. Certainly do not talk to somebody that you have no idea who that person is. I don't even know if that person is from the insurance company. I just don't know. So be very, very careful. Again, this is the kind of stuff that I love speaking with people about because I like to explain to them what the law says and what the insurance company can and cannot do. Okay. That's how I get people's anxiety level down, by explaining to them what to expect.
Short break. We're going to take it now. Bounce back with our main topic and more of your emails and phone calls on the other side as we continue the Disability Law Show. Stay with us.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back to the Disability Law Show. Thanks for hanging in through the break. Reach out to Sivan and his team anytime. The consultations are free, or if you just need to chat, that's always there for you as well. 1-855-821-3000. 5900. Email help@disabilityrights.ca. Main topic time, Sivan, chronic stress and qualifying for disability benefits. Let's dive right into this. First point, is chronic stress considered a disability?
Yes.
Okay.
But I want to explain what we mean by that. When we're looking at disability in the context of long-term disability, many people come to me and say, is chronic stress a disability? Is anxiety a disability? Is depression a disability? Is fibromyalgia? You know, some of these are controversial diagnoses. Some of them are not, but some of them are. And what I tell them is that, look, it's not about whether or not somebody has a list of conditions and that, you know, your condition has to fall on that list. It's whether or not you have a set of symptoms that are disabling you, are not allowing you to carry out the essential tasks of your occupation. And if you have a chronic condition, whether it's chronic stress, chronic pain, whatever it is, then if you have a doctor or doctors that say on paper, right, they write down that because of this condition, you're unable to do the essential tasks of your occupation, or you have difficulty with whatever it is, whatever the symptoms are, memory issues, focus, whatever the issues are. And because of that, you can't do your work, the insurance company ought to accept your application. Now, they ought to accept your application. Does it mean that they do? Unfortunately, in many instances, they don't. Either they'll say that we don't believe that you are totally disabled, according to the policy. We don't believe that you have objective medical documentation or documentation supporting your disability. They give a whole host of excuses. They say reasons, I say excuses. What you need to understand is that unless you have a strange policy, okay, I'm talking about now the general type of policies out there, as long as whatever condition you have, chronic stress, chronic pain, chronic anything, unless you're unable to perform the essential tasks of your occupation, you should get LTD from your insurance company. And if they give you an excuse as to why you are not getting it, give us a call. Here's what we're going to do. When you call me about that, I'm going to ask you for the denial letter, because there's going to be a denial letter. I'm going to ask to see what medical documentation you gave to the insurance company. And if need be, I may ask for a copy of the policy. But most times I don't need that, because the denial letter will reference the particular provisions of the policy that they're denying the application for. And I can tell you literally within a span of a few minutes, 3, 4, 5 minutes, I can tell you, do you qualify or do you not? Is the insurance company correct or not? Like, there's no mystery here. We do this every day. So the answer, John, is yes, if it disables you from performing the essential tasks of your own occupation. That's really what I want people to understand. If your doctor says you're disabled, you can't work, then you can't work. You should be getting LTD.
Second question, what, if any, documentation is required to support a claim for chronic stress?
Same kind of thing as for anything else. There's going to be an application for disability. There is going to be a portion of the form that your doctor has to fill out. Anything else that you can provide the insurance company, any clinical notes and records, any reports you have, anything that basically says, look, this is your condition, this is what you're experiencing, and you can't work as a result. You know, the way to look at it, if you were to kind of zoom out, okay, for the regular layperson, imagine you're going to a judge, forget the insurance company, you're going to a judge, an independent person, objective person, somebody who is not looking at anything emotionally, who has no vested interest in your claim. And you want to convince the judge that you're unable to work because of whatever condition is ailing you, chronic pain, chronic stress, whatever. If you can convince a judge, if you can provide the documentation that says, look, my doctor is saying X, here you go, then there's no reason why that should not persuade the insurance company. So yes, chronic stress, you need to have your doctor provide the information, what it is you're experiencing. If there's a diagnosis of chronic stress, great. If not, what are the symptoms you're experiencing, and the fact that they are not allowing you to work. That's really what you need.
When it comes to stress, I mean, this question probably comes up all the time. Why are claims regarding stress or burnout, for that matter, denied by insurers?
So the two main reasons I see for those denials, there are many reasons, but there's two main ones. Number one, insurance companies are concerned that some people are simply saying that they're stressed when, you know, everybody experiences stress. So why is your stress more than my stress? You know what I mean? Like the adjuster reading the application says, I have my own stresses.
We're all stressed.
We're all stressed, exactly. So why is it that your stress is different? Why should you be on LTD? So there is the inherent skepticism that insurance companies have for a claim for stress, for chronic stress. It doesn't matter, because ultimately, if your doctors confirm that this condition is disabling you from working, that's it. It's checkmate. The insurance company has to approve you. But that's the first reason, the skepticism. The second reason, John, and I think this is important to understand, is that a lot of stress arises from work. A lot of stress arises from the employment environment. And so insurance companies will often say, this is an employment issue. This is not a disability issue. Find a different employer. Sue your employer for constructive dismissal or whatever. Leave us alone. We are not bad boss insurance. We're not bad work environment insurance. We are disability insurance. Again, that ignores the fact that in many cases, maybe the work environment created that stress or helped create that stress, but that stress has now developed into a generalized condition. It doesn't matter if you're working elsewhere now. You are now a stressed fish. Mm-hmm. You now can't work. Doesn't matter where. And sometimes, stress is not in a vacuum. People have stress at work. Oftentimes, there's stress at home too. There's a variety of reasons for the stress. So anyways, the point is, insurance companies oftentimes will deny those kinds of claims for a variety of reasons or excuses. What you need to understand is, as long as your doctor says you are suffering from chronic stress, here are the symptoms, here's why you can't work, the insurance company should approve your claim.
With that, we will take a short break and do an email, some more questions as well on the other side. Stick around for that. Lots more. The Disability Law Show is on the way. Stay with us.
People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Got a few minutes to go here on the Disability Law Show. But after the show, always reach out to Sivan and his team. If it's just a question about something you heard on the show, that's fine, or something personal, no problem. Even a consultation won't cost you anything. So use the number 1-855-821-5900. Back it up maybe with the email, help@disabilityrights.ca. That is where we're going right now. Nina's email today, Sivan, says, I've been asked to sign a letter that allows insurance to estimate CPP disability payments so they begin deducting them. I haven't received approval for CPP disability yet, and I'm not sure that I will. Should I still agree to this?
No.
Okay.
Next question.
Yeah, done.
So let's break this down. Why is the insurance company interested in your CPP disability benefits? Because they're entitled under most policies to get a credit, an offset for whatever CPP disability benefits you get from the government. Let's do the math here. Let's say that you're getting $3,000 in LTD a month. Let's say you apply for CPP disability, you get approved, you're getting paid $1,000 from CPP disability from the government. You're not getting $4,000 in total. You're still getting $3,000, except that the insurance company is now paying you $1,000 less because you're getting that from CPP disability. What's happening here is that the insurance company is wanting this lady to sign a letter that says that they can estimate what it is that she should be getting and then start deducting that. That is, number one, premature. Number two, I haven't seen the policy, but it strikes me as illegal because she hasn't gotten a result yet from the government. She doesn't know if she's going to get approved for CPP disability or not. What I typically see is not somebody being asked to sign a letter. What I typically see is the insurance company saying, apply for CPP disability, or if you don't, we will estimate how much you ought to be getting and start deducting. Again, there's issues with that approach too, but for them here in this case, to ask her to sign that letter to say that she's giving them approval, to me that's preying on the vulnerable. I can't imagine that her policy, her insurance policy, contemplates the insurance company having the right to do so. And again, this goes back to my earlier point, John, which is insurance companies are bound by the policy, by the insurance policy. That's the contract between you and your insurance company. that contract, that policy defines their obligations and their rights. It defines your obligations and your rights. What I would tell this lady, we can do this for her, but she can do it as well. Ask the adjuster, her adjuster, where in the policy does it give the insurance company the right to estimate what she should be getting from CPP disability and then claiming that as credit? Where does it say that? I guarantee you it doesn't say it. You know how I know? Because if the insurance policy said it, they would not need her to sign a letter. So what is she getting out of it, right? I mean, but it's a very conniving way of doing business. To me, that should attract punitive damages. I mean, that's completely inappropriate. But insurance companies, in my experience, take advantage of people all the time. They use people's ignorance, they use people's conditions, especially when you're dealing with mental health and people are vulnerable. It infuriates me, but you know, it also makes it more satisfying to go after these insurance companies and really hammer them, because these things should not happen. These insurance companies are there as a safety net. They're not there. They're not supposed to bully you. They're not supposed to take advantage of you. Yeah, they've been paid for this, by the way. It's not like they're doing this as a charity. They've been collecting premiums, sometimes for decades. So for them to do something like this, for this lady, I mean, come on, that's completely, it's disgusting.
Yeah.
But anyways, we're in the position to help this lady or anybody else who has these kinds of questions. I'm glad that she actually at least checked, because I can tell you, John, for every lady like that that is checking, that is emailing us, how many do you think out there are just going ahead and signing these letters?
MyDisabilityQuestions.com. That is yet another avenue for you to ask questions and possibly get them on the show. It's anonymous, of course. From MyDisabilityQuestions.com, here is the question. Sivan says, after years of struggling with fibromyalgia, my partner started a new job last year and then had a bad fall at home, injured her back. Her doctor supported her disability claim, but after several months, the insurance company denied it, saying her condition was pre-existing. What does this mean?
Well, again, insurance companies, remember I said they will try to use every excuse they have to not pay you your claim. What they're probably saying here is that the fall triggered whatever condition she had that was pre-existing, the fibromyalgia. But here's the deal. Presumably, she's not on disability because of fibromyalgia. There was an underlying condition, maybe, that because of that condition, she was vulnerable, and her fall now caused her injury such that she needs to be off on disability. But the source or the reason why she's on disability is because of the fall. We all have pre-existing conditions. Yeah. You're not perfect, I'm not perfect. I'm close to perfect, but I don't know about you.
I'm very far from it.
You're very far? Okay. None of us are perfect. That's the reality. We all have pre-existing issues, underlying issues. All of us do. Everyone does. So it's important to understand that when the insurance company argues that there is an exclusion that disentitles you from benefits, like a pre-existing condition, again, they may be right, but it's worth checking, because I can tell you on quite a few occasions when we looked into it, they were not right. Or maybe there's an ambiguity. Maybe we're not completely sure. But here's the beauty about insurance law in Canada. Okay? Get this. If there is an ambiguity, if this goes to court, courts interpret ambiguities against insurance companies. That's the general rule. So again, you have more power than you think. Ask questions. You're denied for any reason. Ask us about it. Ask us about it. Come to us. We'll talk to you for free. We'll examine the paperwork. We'll talk to you. We'll tell you what your options are. If the insurance company is right, we'll tell you they're right. But in many cases, in the vast majority of cases of people coming to us, the insurance company is not right. And we explain to people what they can do about it and how we can help them.
And again, doctor's on her side. I'm sure he knows about the fibromyalgia, and he's saying she's disabled and can't work.
You got it. You got it. Exactly. Exactly.
So she's got the medical backing as well.
Which means that we can go after the insurance company and make them pay.
And that is it for this week. Thank you so much for those emails and your phone calls as well. Keep it coming. Keep tuning into the show. You want to reach out anytime. You can do it by phone. Consultation won't cost you a thing. It's a toll-free number, of course, to talk to Sivan and his team. Very knowledgeable. Always ready to talk to you. 1-855-821-5900 for that. Help at disabilityrights.ca. And that last website where we pulled that last question from, MyDisabilityQuestions.com. Free and anonymous. Feel free to use that as much as you would like. And we thank you once again for tuning into the show. We will catch you next time right here on the Disability Law Show. Thanks for watching.